submissions. Misenga Jones versus the Guyana Elections Commission and others.
Good afternoon.
Misenga Jones versus the Guyana Elections Commission and others.
Council, we will move straight into this part of the hearing. We assume that the appearances are as before. And so we move now to Mr. Ramkaran.
May it please your honors, a seminal question to be determined in this case is what can a court do or not do in a case about elections before those elections are completed. This court has the opportunity to determine and should determine the limits of the power courts can exercise when such cases are brought before it. The law is clear and has been applied again and again with almost every issue which concerns the validity of elections and results or the electoral regime should be raised after a declaration of results in an election petition. This very court has decided that on many occasions. But there remains a residual jurisdiction which has developed in Guyanese jurisprudence in which a narrow and limited supervisory role is played by the court to move the electoral process along. This special jurisdiction has been developing since 1998 in Norton. And although Chief Justice Bernard in Norton declined to exercise the jurisdiction to act, she did exercise it in Hamilton in 2001, where she ordered the Chief Election Officer and Elections Commission to comply with Section 841 of the Representation of the People Act. So she ordered the compliance of a section of the law. Since 2001, this special jurisdiction has been exercised 3 times in Holladar, in Moore, and in Jones, all of which were heard in this election season in 2020, which is more than in any other generation before. In Holladar, Chief Justice George, and this would be Holladar number 1 on jurisdiction. I think the decision was delivered on the 8th of March. In Holladar, Chief Justice George, in applying Norton and Hamilton, ruled that the court had jurisdiction to hear an application regarding whether a person exercising authority has complied with his or her statutory duties. And the returning officer in that case, Mr. Mingo, was ordered to comply with the provisions of the Representation of the People Act. In Moore, this court, the Court of Appeal, held that this jurisdiction can be exercised where the court is satisfied that the Elections Commission has acted or is about to act in excess of its constitutional and statutory powers. So in Holladar, it was concerning the failure to exercise in accordance with the Act, and in Moore, it concerned the proposed failure to act in contravention of statutory or constitutional duties. In Jones, which is on the appeal before your honors, Chief Justice George construed the jurisdiction very narrowly, using the peculiar context of the case where an internal impasse exists in GECOM and an interpretation of the Constitution was necessary to determine whether the chairman and GECOM and the chief election officer were acting lawfully. Chief Justice George found that the narrow jurisdiction permitted a limited inquiry into the legal framework guiding the carrying out of election functions, since if the framework were found to be unconstitutional and void, then the exercise of those functions would also be affected. Chief Justice George only accepted such evidence as would permit her to determine the factual matrix necessary to provide the background to the proceedings. She made it clear that it could only be used, this limited jurisdiction could only be used to speed the proceedings along. Now, it is my submission, Your Honors, that these are the parameters of the special, limited, and narrow jurisdiction which has been exercised by courts so far in Guyana. There is no doubt that it is a necessary jurisdiction having regard to Guyana's peculiar electoral history. But the time has now come for this court, in upholding the exercise of that narrow and limited jurisdiction undertaken by Chief Justice George, to set clear parameters on a principled basis for the exercise of the special jurisdiction. This This ruling should uphold Section 140(1) of the Representation of the People Act, which prohibits questions into the validity of the functions of GECOM or its members, and it should uphold the special election petition regime created by the Constitution and the National Assembly Validity of Elections Act, but leave very narrow and limited jurisdiction to the courts to scrutinize where laws have not been complied with or where laws might not be complied with. Whatever jurisdiction which exists, which this court will find, must not be used to delay the process and must not be used to determine the validity of the elections or its results. In this regard, therefore, Your Honors, on jurisdiction, I would urge that Your Honors uphold and apply the approach taken by Chief Justice George in the court below. On the issue of the constitutionality of Section 22 of the Election Laws Amendment Act, in the High Court, Your Honors, Chief Justice George declined to explore the constitutionality of that section because the laws applied by this court, the Court of Appeal, which she found to be binding on her, is that the constitutionality of an electoral law should be raised only in an election petition. And that was defined very recently by Your Honors in Moore. Nevertheless, the appellant's arguments are almost entirely premised on the contention that Section 22, and by extension, Order 60 made thereunder, is unconstitutional. The appellant has studiously avoided analyzing the decision, however, of Justice Ellis in the British Virgin Islands High Court in the OECS in Partner Cells Cabet Parsifal against the Attorney General, a 2018 decision relied upon me in the High Court and in this court. In that case, Justice Ellis extensively analyzed legislation with very similar effect to Section 22. After an exhaustive analysis of the jurisprudence developed on the constitutionality of such legislation, starting with the hurdle of the presumption of constitutionality that the appellant has not tried to overcome, Justice Ellis ruled that where legislation gave the power to an authority to legislate in specific circumstances, that power was neither unconstitutional because it breached the doctrine of the separation of powers, nor was it of a type which was unknown or impermissible. In that case, Justice Ellis eventually ruled that the legislation in question was unconstitutional, but that was only because it was far too wide and unconstrained. Once the policy and principles governing the exercise of the power are clearly set out in the legislation, as they are clearly set out in Section 22, then there is nothing unconstitutional about such a power. It is very clear that Section 22 is extremely narrow and its parameters are clearly set out within it. The Elections Commission can only act where it is necessary and expedient to remove difficulties in the application of 3 named pieces of legislation and related subsidiary legislation, and the power lasts only up to 3 months after elections are concluded. It is clear that the National Assembly, acting as a rational, reasonable, and informed legislature, pursuing a clear purpose in a coherent and principled manner, created Section 22 to give effect to Article 162, 1B of the Constitution. That is why the power exists, that is why Order 60 was created, and that is why we were able to have a recount done on the circumstances which were, to say the least, controversial. Although this court is likely to uphold its recent decision in Moore to find that Section 22 must be challenged in an election petition, it should give the court no anxiety to do so because Section 22 in my submission is very clearly lawful, constitutional, and necessary to resolve impasses that happened which required Order 60 to be created. On the issue of res judicata, Your Honors, most of the judgment of Chief Justice George dealt with the fact that the issues raised in this case, which is now on appeal from her, were already litigated and adjudicated upon in this very election season. It is quite clear to anyone who looks that Ms. Moore, Ms. David, and Ms. Jones are all relitigating the same issues to arrive at different results. In Virgin Atlantic and Zodiac seats, Your Honor, a case in the United Kingdom Supreme Court upon which I have relied, Lord Sumption discussed at paragraphs 17 to 26 of the judgment. Lord Sumption discussed res judicata, issue estoppel, cause of action estoppel, and abuse of the process of the court, and how all of those areas of law tied into each other. He concluded that section of the judgment by saying, where the existence or non-existence of a cause of action has been decided in earlier proceedings, to allow a direct challenge to the outcome, even with changed circumstances with material not available before, offends against the core policy against the relitigation of identical issues. Whether Your Honors find that the issues raised in this case, which have been litigated again and again, constitute res judicata, or they are an abuse of the process of the court, or they constitute issue estoppel, a cause of action estoppel, or as Mr. Mendez has said, they are subject to stare decisis of decisions which have already been issues of law which have already been determined and which apply until set aside. This court has to act. It has to act, and it has to act decisively to prevent persistent relitigation of these issues. Or else there would be no end, Your Honors. There would be no end to these elections. In summary, Your Honors, the court should find no difficulty in dismissing the appeal and in upholding the well-reasoned and coherent judgment of Chief Justice George. Unless there are any questions which Your Honors wish to direct to me, those are the submissions of the 9th respondent.
Well, we thank you, Mr. Ramkaran, for your very crisp submissions. We don't have any questions,
I'm very grateful, Your Honor.
so we will move on to Mr. Ramkaran Sr. Mr. Ramkaran?
My apologies, Your Honors, I was on mute. Thank you very much, Your Honors. May it please Your Honors. Mr. Mayor Robertson began his submissions by complaining about the intrusion of politics. I presume he meant in this matter. Didn't give any particulars, so I don't know what he's talking about. But Your Honors, elections are a matter of high politics. And it is inevitable that in cases concerning elections, politics are going to intrude. Mr. Ramkaran, who just spoke before me, displayed the usual type of approach when talking about our electoral history, which courts and other agencies have shown a marked reluctance to entertain. He referred to it as our peculiar electoral history. Your Honor, that alleged peculiar electoral history has informed everything that is happening today. And standing behind that peculiar electoral history is Guyana's peculiar politics. So courts and other agencies cannot close their eyes to what has happened in our past and in our history. And I would like to say that I, for one, am not going to be intimidated by any person or agency from referring to that history head on where necessary. I believe Your Honors would be relieved when I say that I don't think that would be necessary in this case, but obviously it forms a background to what I'm going to say. Your Honors, Mr. Jeremy seems somewhat befuddled at the number of persons who have entered appearance in this matter. I think there are 11 respondents, and he brought the case against 4. Well, it reflects only that Guyanese have become, and I think it is because of that peculiar electoral history, Guyanese have become very much interested and passionate about defending their democratic rights when they feel that those democratic rights are under challenge, as in this case. And I believe I speak for my colleagues when I say that that is the reason that so many of us have rushed to gather around to defend what we believe are our democratic rights. Your Honors, one of the most important issues that has engaged the Honorable Chief Justice, and I submit that should engage this Honorable Court, is the powers of the Chief Election Officer under Article 177(2). Behind that Article 177(2) is a very long history. And I know I'm going to try Your Honor's patience when I attempt to review how the role of the Chief Elections Officer has developed vis-a-vis GECOM, on how we have reached Article 177(2) today from what it was in the past. Your Honor, it is alleged that the Chief Election Officer has power to determine what the results of the elections should be, and that the Elections Commission is obliged to accept the determination of the Chief Election Officer. Your Honor, in response to that argument, this is what the Honorable Chief Justice found at paragraph 73. Her Honor said, "I do not agree with the submission that the CEO has a constitutional mandate under Article 177. It is the chairperson and GECOM that have the constitutional mandate. The CEO is a functionary of GECOM pursuant to Article 161A and Sections 2 and 7 of the Representation of the People Act. Section 18, which is repeated in Order 70, merely confirms this and the obvious for the avoidance of doubt that the CEO cannot act on his own. In this regard, he has certain duties as regards tabulating results as provided for in Section 96 of the Representation of the People Act. Shortly before this, in connection with the same issue, Her Honor said that the chief election officer is not and cannot be a lone ranger. Your Honor, Section 96(2) of the Representation of the People Act ought not to be interpreted as giving this chief election officer power or authority to determine the final declaration of the results. That power is given to all that the chief election officer is required to do is compile the results, put them in manual and electronic form, and pass them over to GECOM. That history, that was not always so. Why it is not always so? Because counting of the votes at the place of poll was not always the law in Guyana. This occurred in the 1964 regulations, which became the 1964 Representation of the People Act, which was published in the 1973 edition of the Laws of Guyana, which was, that act itself was extensively amended in 1968. And then after 1968, it was recently published again, and it was substantially amended by about a dozen pieces of legislation. But the most important of those amendments took place in 1968, 1985, and 2000. And the year 2000 is significant, but not mentioned also is the year 1990. The Act of 1968, which by which time Guyana had proportional representation, had no provision for counting of the votes at the place of poll. After the closing of the poll under Section 83, all the presiding officer had to do was to pack up the votes and the election material in a required form and deliver them to the returning officer, who would then, under Section 84, count the votes of the district in accordance with the provisions of that part of the Act. But the chief election officer had an overriding power to change that district, to remove the counting from the district in which the returning officer was located, for in the interest of expediency and in the interest of security. Your Honor, Your Honors are not as old as I am and would not recall the events of that era, but they are fresh in the minds of people of my generation about the counting of the votes. Your Honor, in 1990, that changed. What I wish you to note is the power of the chief election officer in that era. The power of the chief election officer to manipulate the place of counting. In 1990, Your Honor, that was changed, the same Section 83. And the presiding officer was required to count the number of votes at the place of poll for each list of candidates. And after those votes were counted, he was required to prepare a statement of poll in many copies deliver them to the officials who were present, and then hand a copy over to the returning officer. He was also required to close off the ballot box in a specific format and under specific rules and deliver that ballot box to the returning officer. Your Honors, under Section 96 of the Act, before the reforms of 1990, 2000, it was the chief election officer who under Section 96, it was the chief election officer. Section 96 then only had Section 96. Now it has Section 96(1) and 96(2). It was the chief election officer who calculated the total number of valid votes which have been cast for each list of candidates. He was the one who did the calculation. And the allocation of seats in the National Assembly and so on was made by him. Well, Section 96 was significantly amended by subsection 2, to which I referred earlier, and which provided that the chief election officer shall prepare a report manually and in electronic form and hand it over to the commission, which shall then consider the report, and on the basis of the report, declare and publish the results. Your Honor, in 2015, there was a widely publicized event as regards our elections, when the PPPC was given one seat in excess of the proportion of votes that it earned at the elections. That was corrected by the commission itself after it noted whatever it was, a mistake or error or whatever. If the Elections Commission did not have that power, and it was only the power of and if that power resided only in the chief election officer, the People's Progressive Party would have been the government, because the votes could not, the report of the chief election officer could not be changed. So on the basis, the words "on the basis" in Section 96(2) gave adequate authority for the for the Elections Commission to manipulate the votes. Your Honor, the chief election officer, the wording in the section is, the chief election officer calculates the votes and prepares a report, and on the basis of the report. And that language certainly gives GECOM the flexibility to make its report. Your Honors, it was the clear objective of Section 96(2) to diminish the power of the chief election officer. And that is the tendency and the trend we see in the development of the legislation from 1990 onwards. The counting of the votes, the power of the chief election officer, the calculation of the votes, the power of the chief election officer. In both cases, those powers were reduced and the powers of GECOM enhanced. Your Honor, under the Constitution, Article 161, Article 469(1), then 1621, say the same provision, provides for the Election Commission to have general direction and supervision over the elections. And then it provides some more details: shall exercise such instructions and take such action appear necessary and expedient to ensure impartiality, fairness, and compliance. Your Honor, the Indian Constitution, Article 324, doesn't have the equivalent of B. Take such steps as are necessary to ensure impartiality. It only has the equivalent of A, shall exercise general direction and supervision. This is what the Indian Constitution says, Article 324. The superintendent's direction and control of the preparation of the electoral rolls for and the conduct of all elections to Parliament and to the legislature of every state and of elections to the offices of President and Vice President held under this Constitution shall be vested in the Commission referred to in this Constitution as the Election Commission. Those are all the broad powers contained in the English Constitution. And this is how, in the Mohinder Singh Gill case, it was described. This shows that subject to any valid law made by the legislature and subject to certain fundamental legal norms, the authority of the Commission under Article 324 is unlimited. Its authority is essentially administrative and marginally even judicative and legislative. It is empowered on its own right under Article 324 of the Constitution to make directions in general in widest terms necessary and also in specific cases in order to facilitate a free and fair election with promptitude. Your Honor, in the past history of Guyana elections, sub-article A of Guyana's Constitution of 1621 has been the issue of wide debate. But here it is in India. Just sub-article A, not B, which enhances and particularizes and defines the powers contained in Article A. In India, Article A standing by itself has all the powers that Article B has given it on its own. So under the Constitution, GECOM has the power to direct the elections, the CEO, and that is confirmed by the legislation referred to by Her Honor and by other legislation, Article 160, in the Constitution, I mean, and as well as other legislation, Section 18 of the Election Laws Amendment Act and so on. Article 161A, 1, 2, 3, 4, and 5 adds to the powers of the Election Commission in relation to GECOM and the CEO. Sub-article 1 says the Election Commission should be...
Ramkaran, we'll ask you to wrap up as soon as you're able to. Your time is up. But we'd like to go on for a few minutes more.
I thank you very much, Your Honor, if I can close off this point. That the Elections Commission shall be responsible for the efficient functioning of the Secretariat, which shall comprise officers and employees. And officers and employees of the Commission are defined in the Elections Commission as in the Representation of the People Act as including the elections officer. There is one point I wish to close off on with your permission. 177.2 in 1980, 177.2, and I have it in my submissions at paragraph, from about paragraph 38, 39, Your Honor. In 1980, 177.2 stopped at the point where the declaration is made by the chairman of the commission in 1980. So in 1980 and before, or up to 1985, up to 1997 actually, the president was declared, was deemed to be the president. Whoever got the higher votes was deemed to be the president and declared by the chairman of the Elections Commission. Later on, it was added that the role of the CEO was added. So by the time the CEO gave a report to the Elections Commission, a president was already deemed to be in existence. So the second half of that sub-article about the CEO was added afterwards. And when he makes his report, we already have a president in place. A president is already deemed to have been elected. And the CEO does not have the power to change that. And that is what, Her Honor, the Chief Justice is trying to say. And that is what I seek to commend to Your Honors. Thank you very much.
Thank you, Mr. Ramkaran. We move on now to Mr. Jonas.
Thank you very much, Your Honor. Your Honor, the central foundational tenet of this application is identical to that of the Yulita Moore application. In both applications, the applicant before you was contending that the statutory procedure in the Representation of the People's Act, by which the votes are counted at the place of poll, the returning officer assesses the SOPs and makes a report to the CEO. The CEO uses those SOPs and makes his advice to GECOM, and GECOM declares. In both cases, it is urged by the applicants that those steps happen automatically and nothing can be done to second guess what is going on. So that in Yulita Moore, when it was found out that the report by Mingo was flawed, Yulita Moore said, you can't have a recount. We are bound by those reports submitted by the ROs. And in this case, before Your Honor, at the next stage, when it is found that an equally unlawful report is made by the CEO to GECOM, this appellant before Your Honor is saying you can't look, GECOM can't look behind that. GECOM is bound by this equally unlawful report made by Mr. Lowenfield. So the underlying principle is the same. And the underlying principle has been clearly rejected by all the courts. Any member of the public can challenge an illegality by one of the officials of GECOM. This was demonstrated by Chief Justice Bernard in the Hamilton case and in the Aubrey Norton case. And this year again was exercised by Chief Justice George in the Holidar case, where Chief Justice George acknowledged the illegality by Mingo in using spreadsheets and directed him to do it properly. And we know from the evidence he did not do it properly. So any member of the public has an interest, a sufficient interest, to challenge an illegality of one of the officials, in contradistinction to GECOM, which has been dealt with thoroughly already. And therefore, the argument cannot stand that you must blindly accept what is known to be an erroneous, an unlawful, a mistaken, a fraudulent, however it went wrong, act by an official and pretend it never happened, therefore perpetrating knowingly an erroneous election. Now, to my surprise, what is being contended here, as was contended at first instance, in the face of the fact that any person in the society has a sufficient interest to challenge these acts, is that GECOM itself, which has superintendence of the conduct of the elections, GECOM itself is bound by a mistaken, unlawful, fraudulent act of its own officials that it employs, that it has the power to hire and fire, that it has the power to direct and supervise, that it has all powers of an employer. GECOM, even if it has knowledge of an unlawful act, somehow can't look behind it. So as my friend Ms. Kite says, and I endorse and recommend her very thorough submissions to Your Honor, what is being sought here is to ask this court to give its stamp of approval to a proven illegality. But of course, Your Honor, that also runs contrary to every known principle of law. It's a clear position, and the 11th named respondent referred to it at paragraph 21 of the submissions before the Honorable Chief Justice, upon which we rely, that where a tribunal has knowledge internally within its own structure of an illegality, of a mistake, it can't turn the Nelson's eye and proceed as if nothing is wrong. Then it is acting unlawfully. It has to correct that illegality, that mistake, that error, that fraud. And having corrected it, it has to move forward. And this was discussed in Fordham on judicial review, referred to in paragraph 21, and the decision of Dyson J. in Bedford County Council in Fitzpatrick was referenced. So, Your Honors, if GECOM, in its internal deliberations, and we are precluded by Section 140, knowing what those internal deliberations are, receives a report that it knows is unlawful, or that it knows it's erroneous, GECOM would be acting unlawfully if it proceeds on that. GECOM would necessarily, especially given its overarching powers under Article 162, GECOM would be mandated, would be only acting lawfully if it corrected that and corrected its employee before moving forward. And that is what GECOM has done. The facts that we know, Your Honor, are that on the 14th of June, the recount having been concluded, GECOM, and GECOM communicates under the legislation, the Elections Law Act, GECOM communicates through its chairman. So GECOM, through the chairman, instructed its chief elections officer to prepare his report based on the numbers of votes as counted in the recount. Now, the appellant before you contends that any report that Mr. Lowenfield thereby submits is binding on GECOM, you can't look behind it. Of course, that was specifically rejected by the Caribbean court in the David case. Because in the David case, when the Caribbean court learned that Mr. Lowenfield had used the excuse of the decision of the Court of Appeal to prefer advice going back and ignoring the recount, on its own motion, there was no application on its own motion, the Caribbean court correctly set that aside as illegal. The Caribbean court said he went on a frolic of his own, he acted unlawfully, and they therefore set it aside as void. So the argument that somehow Mr. Lowenfield's report now, this report now made on the 11th of July, is impervious to examination by GECOM, his boss, borders on the ridiculous. And because we don't know what the internal deliberations of GECOM are, we cannot say GECOM acted wrongly. But this is what we do know, because this is in the affidavits before you, including the affidavit of Ms. Jones at paragraph 25 in her affidavit in support. She says that the chief elections officer used the votes furnished from the returning officers of the 10 districts. So she says, she informs the court that he didn't obey the lawful instructions, the instructions found by the CCJ to be lawful. He didn't obey those lawful instructions. He went back to the proven false report of Mingo, and he used that to make his submission as the premise, the basis of making his submission. And at paragraph 52, Ms. Jones informs that of the letters of 16th June, 9th July, 10th July, and 13th July emanating from GECOM, saying you got to use the recount numbers as already approved and endorsed in the CCJ. So on the facts before the learned Chief Justice at first instance, the undisputed facts, the facts that are on both sides, we know that once again, Lowenfield ignored the instructions of GECOM in preparing his report. And as the affidavit of Barrett Jaglio says at paragraph 49, the results reported in his 11th July tabulation do not report the results of the recount as tabulated by the CEO and submitted on the 13th of June, pursuant to paragraph 12 of the GECOM order. He went back on his own frolic once again and used votes, used accounts that no one can justify, that is within his own secret knowledge. Now, on the face of that, we know there's an illegality because all of these have been dealt with by the various courts. So we know that Mr. Lowenfield's action in his latest report, which Ms. Jones seeks to convince this court is binding on everybody, including his boss, GECOM, we know that that report is unlawful. I wish to endorse what my friend Mr. Khan said concerning the fact that the appellant before you, is in reality a nominal appellant, represented by the same counsel. But the learned Chief Justice, although I think she could have explored that and considered the abuse of process, the learned Chief Justice decided to treat it as a bona fide application. And in paragraph 24 of her judgment, as Your Honors have pointed out, she said, and these are in the words of an expression coined by Mr. Jeremy before her, she said that there was an impasse regarding the decision-making of GECOM because of the obstacle provided by the act of Mr. Lowenfield, which I contend, as is proven and agreed by the CCJ, was unlawful. And this is how she treated the application which was before her. Paragraph 24, she says, I am of the view that the applicant is really seeking the interpretation of the Constitution for a determination whether the chairperson, GECOM, and the CEO are acting lawfully. And it is in this context there can be judicial review. If we can proceed down that road, Your Honors, the only possible conclusion is that it cannot be said that GECOM was acting unlawfully because Section 140 prohibits us from inquiring into their deliberations. But what we do know, and the only possible inference that we can draw, is that they were acting entirely correctly, entirely lawfully, when they said to Mr. Lowenfield, your report of 11th July does not conform to our instructions sent to you on the 16th of June and therefore is unlawful, as was your previous report that was set aside by the CCJ. And therefore, if we treat Ms. Jones' application as bona fide, and we consider the role of the court as acknowledged by Chief Justice George, and as acknowledged in the litany of case law cited by counsel, to smooth this process, the question then arises, how do we deal with this impasse? Now, in my respectful view, and Ms. Kaieteur said it very clearly, there can't be an impasse with your employee. If you have power to hire and fire, as you do under sections 16, 17, and 18 of the Elections Law Act, and after 2 weeks your employee has failed to do what you tell him to do, the impasse should be very short-lived. He may have collected a salary in June, but shouldn't in July, not after 6 weeks. But that is beyond the realm of this court. The learned Chief Justice may have recognized that and therefore decided not to pronounce on how to resolve the impasse. But I would like to recommend to Your Honors that under Section 25 of the High Court Act, the court in every cause or matter can make all orders that it deems just, that as far as possible, all matters in controversy between those parties may be completely and finally determined, and all multiplicity of proceedings concerning any of those matters avoided. More specifically, in Section 8 of the Judicial Review Act, and I know it's probably unnecessary, but I will remind the court that this application at first instance was brought by way of judicial review proceedings under the Act. The remedies that the court may grant are set out in Section 8. And subsection 3 says that any of the remedies mentioned may be applied for together or in the alternative. And the court may grant one or more of them as law and justice may require, and whether sought in the original application or not. The learned Chief Justice, having correctly come to the conclusion, taking the application as bona fide, and I'm reading from paragraph 24 of our judgment, please. I am of the view that the applicant is really seeking the interpretation of the Constitution for a determination whether chairperson, GECOM, CEO are acting lawfully. Well, if the application is bona fide to say to the court, we need to solve this problem, and she has the power to make any order to solve the problem, and on the face of it, on all the evidence before you, and on the binding decision of the CCJ, we know that Mr. Lowenfield is bound by the instructions given to him by GECOM on the 16th of June, and that Mr. Lowenfield acted unlawfully and his advice was set aside when he did not conform to those instructions. And now, for a second time, he has failed unlawfully to conform to those instructions. The learned Chief Justice was eminently equipped to order that the CEO, in order for the smooth process of these elections, and as he had no choice, because he was under the instructions of GECOM, and because those instructions were in writing and are before the court and are undisputed, and because the result of the recount has already been determined by the CCJ to be the applicable count, and has been determined by GECOM to be the applicable count, and any challenge to that must be by elections petition. The learned Chief Justice was quite equipped to say that she is issuing an order to Mr. Lowenfield, directing him to produce his advice on the basis of the letter sent to him by GECOM, because he has no choice. And that is the crux of the mandatory order. There is no other legal option available to him. He cannot second guess it. He cannot go back as he purports to do and use Mr. Mingo's report. He cannot go back as he purported to do and was set aside and invent his own numbers and disenfranchise 100,000 voters. He is an administrative functionary and has no choice. He got to do maths. And the maths, as instructed to him, are based on the recount numbers. And given that the learned Chief Justice had all those facts before her, it was open to her to direct him to do so. And with great respect, it is open to this court as a court empowered under the Court of Appeal Act to make any order which could have been made at first instance, to make that order. And I respectfully point out that in the David case, the Caribbean Court of Justice, without any formal application, made an order setting aside Mr. Lowenfield's decision because it was unlawful, and there was no other possibility but to treat it as unlawful. And I know your honors have asked about the impasse. I believe that there's no impasse in reality because of the power of an employer, but where this court is concerned, if this court is determined to remove the impasse, given the proven legality of what has been done by GECOM and the proven illegality of what has been done by Mr. Lowenfield, there is a course of action available. If I can be of no further assistance to your honors, I would like to endorse and recommend to you the submissions of Ms. Kim Kite and Mr. Kaieteur, and I rely on my written submissions.
Thank you, Mr. Jonas. No questions for you
Thank you very much, Your Honor.
at this point. Mr. Dattadin?
Thank you very much, Your Honors. Good afternoon. We rely on our
Afternoon.
submissions and the issue of jurisdiction, as we have outlined. We would just like to add a little bit to it because of some of the earlier submissions. Your Honor, it is our position that the court has a very narrow jurisdiction to supervise the conduct, and we have outlined why that has arisen. But we wish to raise frontally the jurisdiction issues that have come to this court before. The issue of jurisdiction arose in the Ulita Moore case as to whether or not the court had jurisdiction to hear that matter. The majority of the court said that there was. The minority of the court, we respectfully say, as was borne out by David, had rightly concluded that because it concerned directing GECOM what to do, meaning at that time the issue was whether or not a recount could have been done, that there was no power for the court to direct GECOM and its hand. Now, Your Honor, if we could just go forward quickly to David, the minority view was again upheld in David as it relates to jurisdiction when the CCJ upheld it, and the view was that the conditions that were required under Article 177, that is an elected president, someone had to have been elected, that was a condition precedent, and in fact, the Caribbean Court of Justice ruling was there was no real issue to be interpreted in the Constitution. Your Honor, these proceedings are slightly different. These proceedings fit into the mold of the trilogy of cases of Norton, Hamilton, and Hollander. And the court would have jurisdiction for a very limited purpose. The purpose, as we have identified in our submissions, Your Honor, is really whether a statutory officer is doing his statutory duty. Now, in those proceedings that existed before, and indeed in Hollander, what was ruled is that a statutory officer, as opposed to a member of the commission, there being a distinction between the two. In Hollander, it concerned a direction towards Mr. Mingo, who was not using the statement of polls to do his tabulation. In Norton, it was directed again to the CEO, and indeed it was in Hamilton. But if we could just go through it just briefly, as a general rule, the court would have the ability to review the act or conduct of a public officer. But there are obstacles in the path of that. Firstly is Section 140, which says that you can't receive the deliberations or nor can you look at the conduct of the commission. That, respectfully, Your Honor, does not apply to the Secretariat. And there is, of course, Article 163, which gives an exclusive jurisdiction to the High Court, which was confirmed in David by the Caribbean Court of Justice, that all issues as it related to an election or concerning an election should be by an election petition, and that lay to the High Court alone. Now, Your Honor, if we look at the present appeal that is before...
Mr. Dattadin, just for clarification, you are is it your argument that the situation that arose in Ulita Moore was not amenable to to determination on the Section 140? If at the time, in Ulita Moore, the complaint was that on the question of supervision, that the commission was going beyond its powers. So how should the jurisdiction have been based, that narrow jurisdiction in the Ulita Moore case, which the court assumed what should it have been based on, you say?
Your Honor, with respect to the court, there was no way for this court to have received the evidence of what GECOM was doing. Section 140 of the Representation of the People's Act prevents receipt of that information. It is different if it were an elections petition. 140's bar, the barrier created by 140, would not apply to an elections court. So there was no way for the court, for this court, with great respect, Your Honor, to have come to the conclusion that whatever it was that GECOM was doing, it could or could not have done, because there was no way to receive that evidence.
So you say that it was not properly before the court, that the question of supervision was, in want of a better word, was in jeopardy. You say the court ought to have left everything to the petition. I'm just trying to understand your argument. So, for example, if there is affidavit evidence, as there was in that case, of arrangements that appeared, or maybe, let's leave it like that, appeared to compromise the powers of the commission during the election process, you say that was not amenable to judicial review, should have been left to the election court? Just clarify, please.
Your Honor, as far as it relates to the conduct of the commission, respectfully, yes, Your Honor. As far as it relates to members of the Secretariat, not so. Because Section 140 really only refers to what the commission does, not to what the Secretariat, which is the CEO, the Deputy CEO, and the rest of staff. But the 6 commissioners and the chairman are insulated.
Please go ahead, yes.
Thank you, Your Honor. Your Honor, in dealing with the present appeal, just for completeness, Your Honor, this appeal is against all of the decision in the court below. And there are 23 grounds of appeal, and the appeal is stated to be against the whole of the decision. I would have thought that it meant that the jurisdiction issue that the appellants were against the court below taking jurisdiction. It appears from their submission that that is not so, but we would move on. The general observation, if we can take that into consideration, Your Honor, we can't keep doing the same things over and over. There are specific things that have been repeated throughout our courts. Section 22, Article 162 and 163, and Order 60. Now, Your Honor, what was submitted earlier this morning by Senior Counsel Jeremy was that Section 22 is unconstitutional. Respectfully, Your Honor, if I can reply to that briefly, in Moore, this court decided that it wasn't, but even if it was, or if there was a challenge to it, it had to be by an election petition. And indeed, Your Honor, in Sikumar Singh in 1973, it was ruled, and Chief Justice Bollers was at pains to point out that the challenge to an election quite often involves a series of things, including the validity of legislation and also the validity of regulations that are made. In fact, what was the source of angst in Sikumar Singh was in the 1973 elections. There were issues raised about overseas voting and whether the regulations that were passed and whether the amendments to the laws that were done to facilitate that were in fact lawful. Chief Justice Bollers said that that is a fair complaint, But what you had to do is you had to bring it by way of an election petition. We could not do that before, and we could not grant injunctions to you before the process had come to an end. Now, Your Honor, we take that and we remember that in Esther Pereira, it was indeed an act of parliament that was deemed to have been unconstitutional. And in those proceedings, it was an elections petition where Madam Justice Singh, now chairman, had ruled that the election as a result of a statute that was invalid was vitiated. Now, Your Honor, those proceedings were by an election petition. So the challenge to Section 22 with respect could only be done by an election petition. And similarly, the challenge to Order 60 that has been made with its amendment can only be made by an elections petition, because both of those things are part of GECOM's administration. They're using Article 162 and Section 22 to find a way 140 odd days out of past an election to find a solution. But we keep challenging every issue as it is. We're never going to get to the resolution. Now, Your Honor, with respect, Article 177, which was raised by the Attorney General, has said the sole advice of the CEO is based upon what the declaration must be. But this court has considered already in David what about the sole advice, but it's certainly been dealt with frontally by the CCJ in paragraph 45 of its judgment, where it says the issue of validity as far as it is concerned has already been determined by GECOM, by the persons who were counting the ballots and at the recount station. Now, I take just a short aside, Your Honor, that there could be no complaint, as is made in this case, Jones, about the process not involving returning officers, which is required under sections 84 to 89 of the Representation of the People Act, simply because when the returning officer decided to refuse all of the political parties except for the APNU AFC coalition, everybody else requested a recount. And the returning officer, Mr. Mingo, refused it all and insisted on making his declaration. The commission took a decision that we would conduct a recount. And this court in Ulita Moore said that they did have that power and that they can go ahead and do the recount. And the recount was undertaken. The recount, when the refusal occurred by Mr. Mingo to refuse everybody's request, we were no longer acting under the statutory regime. We departed from that, and as the Caribbean Court of Justice said,
As you just mentioned, Mr. Datadin, those deliberations are not admissible. We don't want to dwell there. So can we please move on?
we dwell on David's ruling that the order made, Order 60, was made to assuage the difficulties that had arisen, and that in the interest of what had transpired, GECOM made an order. And that order was the basis of a recount, which was, by all accounts, what it was. And the court below, Chief Justice George, said that events had overtaken the original declarations because the recount demonstrated that the declaration, at least in District 4, was fanciful. It was a fantasy. It was not based on what was in the ballot boxes. This is public knowledge and known to everyone. So with respect, Your Honor, when the Attorney General, if I could go back to his submission, that it had to be on the sole advice of the CEO, it didn't mean that Mr. Lowenfield could do what he wanted. If we were to look at what has happened so far, Mr. Lowenfield first set first numbers that he put forward, 230 odd thousand votes were deemed to be invalid. In his report number 2, 115,000 votes were deemed to be invalid. And the current report, which is what is the subject in these proceedings, Ms. Jones would like those to be upheld, has 14,000 extra votes that we don't know where they have come from.
Could we look at the principles, please, Mr. Data, then the principles?
Well,
The court is concerned with the principles.
Thank you, Your Honor, but what we were trying to say is this is what GECOM is trying to do. And I endorse what my colleague, Ms. Kite, said when she says that GECOM is trying to administer the election. They are trying to tell their employee, the chief executive officer, what is required of him and what he should do. It appears that he is unwilling to take the supervision. But Your Honor, unless we're playing Sesame Street's Word with Friends, what the Attorney General says about the sole advice of the CEO could not mean that he had a unilateral absolute discretion. Otherwise, what would be the purpose of a vote? So he has to act in the basis of information that he has within him. And that information is the data from the recount, which what we understand from the application is what the chairwoman of GECOM has written to him repeatedly to use in making his declarations. Now, that is dealt with in great detail in the court below, Your Honor. We don't wish to repeat that. Essentially what it is Mr. Lowenfield is not a Lone Ranger, and he does not have this absolute discretion. But Your Honor, if we could go just briefly to the issues which keep coming up, and that is that an election petition is the remedy for all of the complaints that are being raised. Now, it is the remedy, Your Honor, because the law provides for a remedy. It is not true that it is a fact that this is not the first election where complaints have been made about varying things to do with valid votes, to do with conduct of personnel and persons, and even legislation, as in Esther Pereira. But these things all rely on a special jurisdiction of the court, which is created by Article 163, and the court sits as a unique special jurisdiction with specific powers. And those powers are what are required. If indeed what is being said about the validity of votes and about migrant voters and all the other concerns are true, that is the time to ventilate it. But with respect, Your Honors, if we continue to challenge the various statutory provisions and the administrative functioning of GECOM by not so subtle ways of exactness, then we are never going to finish the election cycle. We have to get to the position where this must come to an end, and whatever complaint exists can be fully ventilated at an election petition. This has been the view that has been expressed by the Caribbean Court of Justice in David. It was expressly stated at paragraph 45 of the judgment, Your Honors, that all the complaints which were raised by the representative of APNU AFC, Mr. Harman, could be addressed in an elections petition. And all of those complaints have already been communicated to GECOM. And GECOM...
Your time is up, so could you wrap up, please?
Yes, please, Your Honor. If I could only deal with one final aspect as to res judicata. Your Honor, this is public interest litigation. Any citizen can bring it, and therefore any citizen is representative of a group or class. Any citizen has brought it in Moore, and any citizen has brought it in David, and now it's any citizen bringing it in Morgan. They are represented by the same attorneys fashioning the same arguments. My colleague, Mr. Khan, pointed out just how much it has gone down that road. And we wish to raise to the court that res judicata issue estoppel must apply. Additionally, we wish to endorse what my friend Mr. Jonas and Mr. Khan has said as it relates to the powers of this court. Guyana's democracy is on its knees, Your Honor. We can't keep doing this. We have to have a resolution, and the resolution respectfully, if we take Section 25 of the High Court Act, along with Section 8 of the Judicial Review Act, as has been adumbrated in detail by my colleague, Mr. Jonas, this court has the power to say to the CEO that you are subject, Section 18 makes you subject to the Commission. The Commission has a power under Article 162 to direct their staff. You have been directed to do something, and you should do as you are directed. And we pray that this court take that step so we do not continuously have to go through these cycles. Your Honor, unless I could be of any further assistance, those are the submissions.
Thank you, Mr. Datadin. We'll allow a reply on behalf of, well, from the appellants on the respondents' arguments in the main appeal. So, Mr. Jeremy, please go ahead.
Thank you, Your Honor.
One moment, please. Mr. Jeremy, how much time did we tell you at the case management? We're looking at 15 minutes for you to wrap up.
Your Honor, I was told, my instructor attorney tells me that I was told that I have 30 minutes. I think it is impossible for me to reply to 10 respondents, 4 of whom I have sued, and 6 or 8 of whom...
Okay, yes. Okay, go ahead, please. We may have told you that at the case management, so we'll stick to that.
Thank you, Your Honor. Your Honor, I must begin on an unfortunate note, but it is my duty as counsel to make the arguments that I must make. My learned friend, Mr. Jonas, and accompanied ably by his 2 colleagues, I believe Mr. Khan, I don't wish to name anyone without just cause, and Mr. Datadin, for their respective clients, have said words to the effect that because I and my team, we act for the 3 applicants in the respective proceedings, that brings us, and I include by the use of the word us, that brings us within the res judicata principle. That is wrong. It should be condemned, and my colleagues should be ashamed to make that submission. It is not a submission that has been made by anyone else. So I take umbrage at the fact that, and I repeat, that Mr. Jonas permits himself to say that the Chief Justice treated the application as a bona fide application. Your Honor, she had no choice but to do that. It is a bona fide application. And my learned friends ought to reflect on what they have implied, that it is not in fact a bona fide application. The Chief Justice treated the application as a bona fide application because it was a bona fide application within the law and within the permit of the apex court, the Caribbean Court of Justice. Now, in the same breath, he suggests that we are somehow debarring our clients, the fact that we are doing our legal and ethical duty to represent our clients, that we are barring our clients from raising or from dealing with the issues of res judicata which have been raised. Now, I would just like to, having put that aside, I would just like to speak to the following issues. I'm going to deal with the application and what my learned friends have, all 10 or 8 or 6 of them have said of the applications. I'm going to speak to res judicata and what they have spoken of in respect of res judicata. I will then turn to section 22, and in particular, the argument of addressed at length in Petrie by my learned friends of Petrie and Sikuma, that now is not the time to raise that allegation, the allegation that the section is unconstitutional. If not now, when? I'll turn then to the declarations that they say should properly be set aside, and I will close by that, and I will not deign to use an adjective on the submission of Mr. Jonas, that your lordships have the power to essentially fire the chief executive officer. So I will treat with that under the heading that the CEO can't be compelled to defy the law, which is what they seek to do. My ladies and my lord, the submission of my client is that the CEO has produced a report and advice that is consistent in every material respect with the Constitution, the Representation of the People Act, and primary legislation. To base any report on Order 60 as amended, as the others argue, would be wholly inconsistent with Can I speak? To base
Lost
any
you for a few minutes, Mr. Jeremy.
Yes.
Yes, we're hearing you now.
Okay, I'm sorry. Okay. To base any report on Order 60 as amended, as my learned friends will argue, would be wholly inconsistent with Article 177(2)(b) of the Constitution, the provisions of the Representation of the People Act 1964, in particular sections 84, 89, 1F, and 96. And I say, in defiance of the dicta of the Caribbean Court of Justice, the CCJ ruled in David that the Court of Appeal was wrong to treat Order 60 as creating a new electoral regime. It emphasized that no part of Order 60 could have any effect, and this is basic law, and it is intellectual dishonesty to say otherwise. No part of Order 60 could have any effect where it is inconsistent with the Constitution And that's why this morning I cited Article 8. The Constitution is the supreme law. It emphasized that no part of Order 60 could have any effect where it was inconsistent with the Constitution or primary legislation. And it observed that this was a matter of elementary constitutional law. I happen to teach, and this is one of the first principles that is taught. Order 60, Your Honors, is deeply flawed. It is beyond redemption. The CCJ also observed that it is for GECOM to ensure that the election results are swiftly declared in, and I reiterate this point, in accordance with the laws of Guyana. That is what the CEO has done. He has prepared a report that is consistent in every material particular with the laws of Guyana. He is absolutely correct in taking that course, and to urge your lordships to fire him for that. Well, I think your lordships will deal with that submission with the brevity that it deserves. What GECOM and its chair are demanding of him is that he knowingly and willfully produce a different report, one based on Order 60, even though such a report would be manifestly contrary to the laws of Guyana, the Constitution, and the legislation. The Constitution must take precedence. GECOM and its chair must accept the advice of the CEO's most recent report and act in accordance with sections 177, Article 177, 2B of the Constitution. If there are any challenges to the CEO's report and advice and the results on which it relies, that can only be done as pointed out by the CCJ by way of election petition to the High Court pursuant to Article 162(1)(b) of the Constitution. It is the High Court that has, and I emphasize these words, exclusive jurisdiction to determine the questions that the chairperson of GECOM seeks to arrogate herself. So the choice is plain, and it is simple. Which is to take precedence? The tertiary legislation of Order 60 or the fundamental provisions of the Constitution and primary legislation contained in Section 96 of the ROPA? My client submits there can be only one lawful, legitimate answer. The Constitution and the ROPA must prevail. The court should find that the CEO is correct. GECOM and its chair are under a statutory obligation to accept the advice that he has tendered in his most recent report. GECOM and the chair must now ensure that the results contained in the CEO's report are swiftly declared, as some of my colleagues have asked for, in accordance with the laws of Guyana. Swiftly. The inescapable fact is that those responsible for framing Order 60 inexcusably, and I heard Ms. Kite, I heard her submissions, I heard her make bold to speak of fraud today in this court. The inescapable fact is that those responsible for framing Order 60 inexcusably failed to ensure that it accorded with the Constitution and the ROPA. We have now been put right by the CCJ with some basic law on the primacy of one piece of legislation, the supremacy of the Constitution. Order 60 is fatally flawed. It is beyond redemption. As I said in the court below, all the king's horses, all the king's men cannot put this piece of subsidiary legislation back together again. And that is something I learned when I was 5 years old. Humpty Dumpty, it's a nursery rhyme. Order 60, as far as the preparation of the CEO's report is concerned, is, quite frankly, hopeless. The CEO, faced with that stark reality, has done the very best he possibly could to salvage the elections. That is to say, he's counted all the votes that are valid within the meaning of the ROPA and Article 177 2B of the Constitution. My learned friends, Mr. Mendez for Jagdio and Ali, who cried plaintively, fraud, fraud. The place to make those cries are in an election petition pursuant to Article 163 2B of the Constitution. That is where such allegations can be investigated and decisions made as to whether they are well-founded or not. Now is not the time, it is not the place. What we are concerned with here are questions of constitutional law, not a trial on unproven and even fanciful allegations concerning the conduct of the elections. And that's what I propose to say on my overview. Now, in respect of res judicata, everyone here knows, and this is again something that first-year law students will help us with. The test for res judicata is laid down in Garraway versus Ronald Williams. There are three elements. There must be an earlier decision covering the issue. There must be a final decision, not as my learned friends skirt around, on the merits of that issue. And three, the earlier suit must involve the same parties or parties in privity with the original parties. Well, since my learned friends couldn't get around three, they seek to throw words at the attorneys for Ms. David, Ms. Moore, and Ms. Jones. They cannot satisfy those tests. A decision by a tribunal that it has no jurisdiction will not support a plea of res judicata on the merits. Such a decision does not determine the merits of the dispute, and that is Pinnock and the Senakis. Now, it cannot be said that the three paragraphs in the Court of Appeals decision in Moore, at paragraphs 105 to 7, represent a decision on the merits of the issue of the constitutionality of Section 22. And it would be intellectually dishonest again for them to say that Moore had anything to do with Order 60, which was not even in existence at the time that Moore was decided. So res judicata is out of the window. The Court of Appeal in Moore merely addressed the issue of the constitutionality of Section 22 on a procedural point. The court never declared Section 22 to be constitutional or unconstitutional. The merits are still unaddressed. They're out on that too. Generally, the principle of res judicata cannot apply to a changing situation where new facts have arisen, such as the case here. After the Eslin David decision, the CEO submitted his report. That's at paragraph 61 of the affidavit of Jones. GECOM has refused to accept the report and they did that on the 11th of July 2020. That's at paragraph 61 and 62 of the affidavit of Jones. Mr. Khan says both Moore and Holiday are final decisions. Yes, but they do not decide the merits of the case before this court for the reasons that I've given. Order 60 wasn't even in existence. Moore decided the ability to do a recount, simpliciter. It did not consider whether a recount could be done, in fact, after the Order 60 process had come into being. Holiday decided that the court had jurisdiction to treat with breaches of legal process and to smoothen or correct the processes so that an election could be declared quickly. So those who say that, oh, it's taking 4 months or 5 months, should ask themselves why they found themselves in court in Holiday. Mr. Mendez admitted, and I took the time that he did this at 11:40, that there was no challenge to the validity of Order 60 before the CCG. We make such a challenge now, and that, Your Honors, is the end of the Order 6 of the red judicata point, and it should be buried and put in the sea of forgetfulness. Now, if I could turn to Section 22 and the constitutionality in respect of Petrie and Sikumar Singh. To resolve the impasse, this court is required to make a determination as to the constitutionality and or the extent of the powers of GECOM under Section 22 of the Election Laws Amendment Act. Petrie and Sikumar Singh are both distinguishable. They are not similar to the case at bar. What underpins those decisions is the notion, which is accepted throughout the Commonwealth, that elections must be dealt with swiftly, and that you take what you can by way of an election petition. But as the learned Chief Justice said in Holiday, the dispute and the very narrow window for judicial review in matters of this type is when judicial review is necessary to smoothen the process towards the declaration of the result. So both of those cases dealt with, Petrie and Sikumar Singh dealt with the constitutionality of legislation which sought to prevent an election. And the court said, understandably, no, we have no objection. We have no objection to that. Those cases are correctly decided. What you have before you is a dispute on which requires you to determine constitutionality of action. And that dispute has to be resolved before we get to how we treat with the declaration of the election. Now, I turn in the time that I have left to the declarations. And my little friends say that the declarations are to be set aside. But
you have 5 minutes, Mr. Jeremy, 5 minutes left.
Thank you, Your Honor. But even Order 60, as flawed as it is in the recital, it says, and whereas the declarations of results pursuant to Section 84 and so on have been made, when declarations have been made, there is but one way to treat with those declarations which have been made. It is by way of an election petition. We know that. And the two Indian cases that I cited are on all fours. In Sala versus State of Maharashtra and Sundar Singh versus State of Haryana. In those cases, Ms. Kite's plaintiff remarks about fraud, fraud, fraud. We are the ones who say fraud. This court is not the venue. It is an election court that deals with that. In those cases, the facts were quite clear that errors were made. Candidates who, it was discovered afterwards, had received more votes were declared to be defeated at the polls. But the court upheld the erroneous declarations since there exists no power at common law or in equity for the court, far less a public executive authority, far less a chairperson, to set aside, modify, replace, or alter declarations which have already been made. That was something that existed only in the House of Representatives historically, and that jurisdiction was transferred to the courts by statute and by virtue of Article 163 of the Guyanese Constitution. See Petrie at page 300 and 300C. Now, I turn to the last point that was raised by my learned friends, who urged you to essentially issue an order to fire the CEO. Your Honors, the CEO...
I didn't think that was what the court was being urged to do. Mr. Jeremy, my understanding was that we ought to, as the Chief Justice ordered, follow that same path. That was what I understood the submission to be.
Okay. I stand corrected.
Mr. Jonas said, as I understood him, that the court ought to make similar orders, but certainly not to step in as an employer. I didn't understand that was what he was urging. So
Very
anyway,
good.
let's move on quickly, Mr. Jeremy. Your time is, I think, up.
Yeah, well, my lady,
But we'll let you wrap up in a few seconds.
Yeah. Well, my lady, GECOM can't use Section 18 of the election laws to compel the CEO to commit an illegal act. Quite usefully, the 7th and 8th respondents rely on the authority of the Prime Minister versus the Governor General. That's 2001 at page 432, in which it is stated that an advice, we say an instruction, contrary to law or lacking legitimacy, or which is unconstitutional, cannot be the advice contemplated under the relevant act. In this case, the only advice contemplated for the chair to act upon under Article 177 is the advice of the CEO rendered pursuant to his independent discretion. We say that the CEO was quite correct in rejecting the instructions to act in breach of the RPA. And contrary to what my learned friends say, if you didn't say to fire him, he said something about employer and what he knows what an employer does. To act in breach of the RPA, since neither he nor GECOM possessed power to redeclare results. That's to be taken up on an election petition. But I just need one more minute. Ulita Moore, which your Lordship, your Honor sat on, never sanctioned the recount, nor did it sanction GECOM to go out and invalidate declarations already validly made. What Ulita Moore said at 109 was that it was in GECOM's functions to resolve controversies as part of its responsibilities to deliver the results of the elections. But we know now from the CCJ decision in David that GECOM has no power to resolve controversies where those controversies involve GECOM exercising a power which contradicts the, the express provisions of the Constitution. See paragraph 41 of the decision. We say GECOM cannot invalidate declarations already made for the same reason. What is missing from David and Moore is that those decisions never gave any weight to the fact that declarations had already been made. That's to be found in the Gazette, the gazetted order produced by GECOM quite helpfully itself. My lady, that is the reply, submissions in reply for the appellant.
Yes, thank you, Mr. Jeremy. We move now to arguments. There's a call for a 10-minute break. And so we'll adjourn for 10 minutes and resume with arguments on the cross appeal. Let's synchronize our time, please. We'll be resuming, we're taking the time now to be 2:10. We'll be resuming at 2:20 with arguments on the cross appeal. We'll start with Mr. Mendez. He filed the first cross appeal. We'll give him 15 minutes on his argument, for his arguments, followed by the Attorney General, 15 minutes, and then we'll allow Mr. Jeremy 15 minutes. Mr. Mendez and Mr. Williams, you would want your final replies after that? Mr. Mendez, would you want?
As I thought Mr. Jeremy had already dealt with my cross appeal, but certainly if he's been allowed to reply and to repeat his objections to the cross appeal, then I would want to respond, please.
Pardon me?
Yes, I would want to respond as well, if Mr. Jeremy is going to reply.
Your Honor, Mr. John Jeremy, Your Honor.
Yes, Mr. Jeremy.
I am finished for the afternoon. I do not need to reply to whatever Mr. Mendez has to say.
I see. Thank you. So we'll allow Mr. Mendez 15 minutes and Mr. Williams 15 minutes on their cross appeals and close off the arguments at that point and today's hearing. So we'll be resuming at 2:20. Thank you.
Much obliged.
Commission and others.
We resume, Council, starting with Mr. Mendez.
Thank you very much, Your Honor. If I may address the question which you had directed my attention to earlier today, Your Honor, in relation to the reach of Section 140 of the Representation of the People Act. You asked me whether that section covered functions of the Elections Commission vested in it by the Constitution. My respectful answer to that question is decidedly yes. What Section 140 says is no question whether any function of the Elections Commission or any of its members has been performed validly or at all shall be inquired into in any court. It says any function, it doesn't say any function vested in it by statute other than the Constitution. It refers to any function. And I would have asked you to read that in conjunction with Article 162(1) of the Constitution, which says that the Elections Commission shall have such functions connected with or relating to the conduct of elections as are conferred upon it by or under this Constitution or subject thereto any act of Parliament. So the functions of the Commission consist of those functions vested in it by the Constitution, those functions vested in it by the Representation of the People Act, as well as the Election Laws Amendment Act, in particular Section 22. So all of those are functions of the Commission, and they are all caught by Section 40. So prima facie, therefore, what Section 40 means is that none of those functions can be inquired into except on an election petition. Now, Your Honors, that is in fact, I believe, the view of His Honor, Mr. Justice Prasad, who, when he expressed in his dissenting decision in the Judicature case, which you would see at paragraph 25, I will not read it in order to save time, but he expressed the view there that Section 40 precludes the court from trespassing. Now, as we pointed out in our submissions, the Judicature decision must now be read in light of the decision of the Caribbean Court of Justice in the Eslin David appeal. And you will have seen from our submissions that we pointed out that the CCJ applied the general principle that is an important part of election law, that challenges to the validity of an election must be brought after the election is declared and not before. So that, with respect, that principle is inconsistent with any court intervening to question anything that the Commission has done that goes to the validity of an election before the election is declared. And you will have seen at paragraph 40 of the judgment, the court says this is the CCJ, the exclusive jurisdiction of the High Court through Article 163 to determine, among other matters, any question in relation to whether an election has been lawfully conducted or the result affected by any unlawful act or omission was naturally unaffected by Order 60. That article is constitutional in character, and it establishes a comprehensive regime for challenges to the election. I repeat, it establishes a comprehensive regime for the challenges to the election. And you recall that in the previous decision of the court in Ram, the court specifically relied on the Petrie decision. So the court was obviously aware that even constitutional issues challenging an election would have to be brought by way of election petition. And in the last line of paragraph 40, the court said this process and utilization of it are fundamental to the electoral system, the legitimacy of elections, and democratic governance in Guyana. And then later on in paragraph 47, in the last sentence, the court said, whatever allegations of irregularity attended those votes, and we neither agree nor disagree as is the existence of such regularities, must be adjudged by the High Court under Article 163, as was correctly stated by the chairperson of GECOM. And it's important that in that sentence, the CCJ footnoted a reference to Section 140 of the Representation of the People Act, which it said provides that questions as to the performance by GECOM of its functions are to be inquired into pursuant to the jurisdiction conferred by the Constitution under Article 163. With respect, Your Honors, the decision in Ulita Moore that the court can intervene to review decisions of the commission on the basis that they have acted contrary to the Constitution or unlawfully, do not sit well with those pronouncements of the CCJ. In what I have just read to you, and indeed in reading the entire judgment of the court is adopting the position that these challenges to the election must be taken after the election and not before, by way of an election petition. Of course, we are talking about challenges to the validity of the election, and this is exactly what the appellants are doing in this case, because GECOM has taken the position that the election must be determined in accordance with the recount. And they are saying that any election declared in accordance with the recount will be an unlawful election. That is the precise type of question that one would take on an election petition. Whatever is the nature, whatever is the source of illegality, it does not matter, as the authorities have indicated, time immemorial right across the Caribbean. If you're saying that what has been done violates the Constitution, then you take it by election petition. If you're saying what is done violates the Representation of People Act or any other legislation, you take that by way of an election petition. This is a direct challenge to the validity of the election as GECOM thinks it should be dealt with, and therefore it is to be dealt with by an election petition. Now, and this is why we say in our cross appeal that the Honorable Chief Justice went beyond what is permissible, that is to say, to ensure the smooth progress of an election and to ensure that it is completed by saying that she could inquire into questions of constitutionality and legality. And that is the basis upon which we support the cross appeal. The second aspect of the cross appeal is premised upon, and I emphasize, is premised upon a finding by this court that it can inquire into the validity of the recount as the appellants invite the court to do. Now, I understand them to be saying that you can do that. Well, I'm not on a number of bases. They're saying what it is part and parcel of the jurisdictions that the court has exercised in the past of ensuring a smooth progress of the election, or to complete the election. Or they say, I think that you should intervene because it involves questions concerning violations of the Constitution. That is the basis upon which they're saying that you can intervene at this stage. And we respectfully submit that if you are going to exercise a jurisdiction on any of those bases, then they logically and fairly, you cannot exclude a challenge to Mingo's declaration. And I say it for this reason. I should say another basis upon which I understood Mr. Robertson to say that you could intervene is that in your judgment in Ulita Moore, he says that what you were really deciding when you said that the constitutionality of Section 22 would have to be dealt with an election petition is that you were saying that you could not deal with it, you could only deal with it in a full trial, and you were not having a full trial at that stage. And he's saying, well, we now have a full trial, and therefore you can deal with the constitutionality of Section 22. Well, we have had a full trial in relation to Mr. Mingo's declaration. As a matter of fact, the allegation that Mr. Mingo's declaration is fraudulent is one that has been made repeatedly in the myriad proceedings. The evidence has been put before the court over and over, and no one has disputed it. As a matter of fact, no one. The Attorney General has been in these proceedings, and he has not once suggested that Mingo did not add 19,000 votes for the PNU that did not exist. This appellant has not suggested it once. Her attorneys in the court below and here has not suggested it once. As a matter of fact, there is no dispute of fact before the court concerning Mingo's declaration. None. And so therefore there's no trial to be had. Adopting Mr. Robertson's formulation as to why you should intervene, there is no trial to be had on the question whether Mingo's declaration is fraudulent, because nobody disputes the fact. The CEO himself has produced a recount. He has produced documents showing the ballots that were counted in District 4. And he has put his signature to it saying that those are the valid votes. That's what he called it. Those are the words he used in his report. And they show that Mr. Mingo gave APNU net 119,116 more votes than were inside of the box. That's the point. Now, so if we are doing it on the basis that, well, we have had a trial, well, we have had one. There has been a trial and it is not in dispute. So if we are going to do it on the basis, well, we are smoothing over the election, we are just making sure people do what they're supposed to do. Well, all Mr. Mingo was supposed to do under Section 84.1 was to add up the votes on the statements of the poll. That's all he was supposed to do. And it is now plain that he didn't add them up. If he had added them up, he would have gotten the same result that the recount has now shown. So he did something else beside adding up. So if all we are concerned with is to ensure that public officials carry out the duties under the Act, and we're not intervening any more than that, then that is also clear. You can intervene on that basis. He didn't add it up. I don't know what he did, where he got the votes from, and this is why we say it had to have been fraud. The last basis upon which I understand it's being said that you could intervene at this stage is because questions of breach of the...
Your Honor, may I just interject because I have given up my right?
No, Mr. Jeremy, afterwards, please. Not now.
Okay.
Yes, Mr. Mendez.
The last basis upon which it is said that you can intervene is that there's a breach of the Constitution. Well, we have set out in our submissions that Guyana is declared to be a sovereign democratic country. People have the right to vote. It's declared that the people are sovereign, and they express that sovereignty through their representatives. The facts before you indicate that the people of Guyana have decided that their representatives are to be the PPP. That is what sovereign democracy means, that the people get to decide who are to represent them. The people get to decide who is the president.
I think the point is well made, Mr. Mendez. I
The
think
point that I
the
make,
point is very well made, yes.
The point is that Mr. Mingo, by his declaration, by his failing to add up properly, whatever he did has violated the Constitution. If that is the basis upon which you are intervening in order to declare the recount invalid, if that is what you are going to accede to that invitation, then you must also accede to the invitation to find that Mr. Mingo's declaration violates the Constitution. Basically, Your Honors, at the end of the day, what they are asking you to do, and you can't ignore it if you are going down this road, what they are asking you to do is basically to sanction Mr. Mingo's fraud. They are asking you to pollute the streams of justice.
Well, Mr. Mendez, what I hope you would help the court with is to express your views on when the court can intervene. You say if it's to smooth out a process, the election process, to make sure that persons do what they have to do. The court thought that, at least the majority in Ulita Moore thought that if it appeared that something was about to happen, that control of the process was about to be relinquished, that the court could intervene. I understand that that is not a basis, you say, on which the court could have intervened. So I'm asking you, what do you say are the categories of situations that allow the court to intervene?
What I'm saying, Your Honor, is that you are allowed to intervene in order to ensure that the process is completed. And in the circumstances of this case, the only intervention that you can make is to require Mr. Lowenfield to comply with GECOM's direction to prepare his report in accordance with the recount. That is the only basis upon which you can intervene. Yes. My case is, and it has been from the start, you cannot intervene to deal with any of the other allegations of invalidity. That is to say, our allegations of invalidity or the appellant's allegations of invalidity or the Attorney General's allegations of invalidity. We say you can't intervene to deal with any of them. But our cross appeal is this: if you are persuaded to intervene to consider the validity of the recount, then you have to consider our allegations of invalidity as well. In other words, what is good for the goose must be good for the gander. In other
I
words, there must
understand
be
that. Yes, but yes, I understand you clearly, Mr. Mendez. I'm speaking more generally. This is not a case that involves Section 140, but because you've raised Section 140 as a matter of interest, I'm asking. I understand the points you're making regarding the recount, regarding the report. Those points are made in your written submissions and reinforced in your oral arguments. But on that other point, because that issue has come up tangentially, I would say, in this case, you say that the High Court can intervene when the process needs to be straightened out. That happened in Norton's case, and it happened in Holidar, and you say, to some extent, it happened here. You agree that with the Chief Justice in this case that that needed to be done. I'm merely asking whether, if not in this case, but in another case, the court believes, the High Court is satisfied that some control, for example, is being relinquished or something like that is going to take place, which is contrary to the Constitution. Is the court allowed to intervene, or does that become as an Article 163 issue as well? It's a tangential point. This is not a case that involves 140, but I ask it in relation to the Judicature matter. I don't know if you wish to address it.
Certainly, Your Honors. What I'm saying is that, first of all, with respect, this is a Section 140 case, because we are saying, and this is our response to the appellant, that they cannot seek any relief that challenges what GECOM is doing, because the court is precluded by Section 140 from doing that. Section 140 does not apply to the CEO because he is not a member of GECOM, and therefore the court can intervene on the limited basis that we are suggesting to direct him to complete the process by complying with GECOM's order. Generally speaking, we have expressed, of course, everything is fact specific, will be. We are saying as a general principle, the court can intervene to ensure that the election process is completed. For example, if a returning officer refused to make a declaration under Section 84 of the RPA, then the court can intervene and direct him to make the report, to make the declaration. Now, that is not dealing with any question concerning the validity of votes or not. It is just directing him to do what he has to do so that the election can go forward. If the CEO refused to give a report under Section 96, then similarly, he will be preventing the election process from being completed, and the court can intervene in order to give him a direction. Again, the court will not be commenting upon the validity of the election or not, just requiring him to do his duty. This is what, in this particular instance, this is what is happening. GECOM has issued a direction in accordance with the law as it exists, including Order 60. And he is refusing to do what he has to do so that the election process can be completed, so that the court can intervene in that instance. Dealing directly with the Judicature case, Your Honor, you will recall that we argued in that case that you could not intervene. Section 140 prevented the court from intervening, even to question the GECOM's decision to allow CARICOM to participate. The court did not agree with that, and that issue is over and done with.
Well, that was the issue actually, but we wouldn't press that. We wouldn't press the issue, but that was what I was interested to pursue.
But in my respectful view, Your Honors, is that issue would also be one that you would have to take up in an election petition, because that goes to the validity of what GECOM is doing. It goes to the validity of the conduct of the election. And any question concerning the validity of the conduct of the election, as the CCJ has said. They've described it in a number of different ways. They use the word fundamental irregularities. And what could be more fundamental than an allegation that the Constitution has been violated? All of those things the CCJ is saying must be dealt with by way of election petition. That is what Petri has said. That is what Sikuma has said for years and years. So that would be my direct answer to your question. But of course, that issue has been already resolved in the Ulitimo case. And the GECOM has followed obviously the decision and did not involve CARICOM in the supervision of the RECOM. So that aspect was corrected. But we are back to square one again when the same issues as the validity of the RECOM are being raised, but on same grounds as before: constitutionality, retrospectivity, etc., etc. The same questions have come back before the court again, and we repeat what we have said. And on this occasion, we rely on the court's judgment in Ulitimo, where you have said that these are matters that must be dealt with by an election petition. Jump high, jump low. The appellant cannot get around the very clear pronouncements of this court in that case. And you will see, Your Honors, that I have made my submissions without making any personal attacks on any of my learned friends, unless there's anything else that I can assist the court with.
Thank you, Mr. Mendez. Mr. Williams?
Yes, please, Your Honors. I smile, and I'm happy for the explanation or clarification by my learned friend, Mr. Mendez, that he hasn't attacked anyone. But in his reply, Your Honors, if I might respectfully refer you to that reply, in challenging my submission in relation to the chairman of GECOM having a duty and being obliged under the Constitution to make the declaration acting only on the advice of the CEO. When my learned friend proffered a case, Yulufa Alu, the Prime Minister versus the Governor General, 2001, reported in the law reports of the Commonwealth. And he was saying that an advice contrary to law or lacking legitimacy or which is unconstitutional cannot be the type of advice contemplated by Section 201, and the Governor General must be entitled to disregard it or to refuse to act on it. Our understanding is that he's saying that equally the chairman of GECOM can refuse to accept the advice of the CEO if these conditions apply to the advice. And that's the problem that Mr. Mendez will be confronted with. Because whether Mr. Lowenfield's report is contrary to law or lacking legitimacy or which is unconstitutional cannot be determined by GECOM. That will have to go to an election petition court. That is the clear fact in relation to this matter, because there's no way GECOM could determine whether the votes are right or whether they were properly counted, etc. And also, this is wrapped up. This is wrapped up in the 10 declarations that were made earlier, including the one by Mr. Mingo. And I would have been happy if Mr. Mendez had clarified the issue even further by referring this honorable court to the decision in Jagdio versus the returning officer of Region 4, the CEO and GECOM, in which Mr. Jagdio challenged the declaration of Mr. Mingo. And that would have been the second declaration that Mr. Mingo had made after the first one was quashed by the Lord Chief Justice, who sent him back on the directions. Sent him back on the directions as to how to conduct that procedure. And even before—
You're talking about Holodar's case?
No, the second declaration was challenged by Mr. Mendez acting for Mr. Jagdio before Justice Holder. And the challenge to the second declaration was the same thing that they had alleged, that he wasn't following the Chief Justice's order and there was fraud and all these things. And Mr. Mendes knows that the Honorable Justice Holder told him and ruled that he didn't have jurisdiction to deal with that challenge to Mr. Mingo's declaration, and that had to go to the election petition court. And Your Honors, that decision of Justice Holder was never challenged. It was never appealed by
Could you
Mr.
start your video, please, Mr. Williams?
Pardon me, Your
We're not
Honor?
seeing you.
Oh, I don't think, sorry about that. Yes, please. Am I being seen now? Yes.
Yes, at this point.
Thank you, Your Honor. And I'm saying, if the recourse to the courts, our honorable court, by Mr. Javier, directly challenging the second declaration by Mr. Mingo had been raised here, we would have been satisfied. Because in that case, the learned judge, Justice Holder, said, Mr. Mendes concedes that the complaints made about the returning officer's conduct falls within Article 163(1)(b) of the Constitution, and as such, the High Court has exclusive jurisdiction to hear that complaint. Exclusive jurisdiction. So Mr. Mendes conceded that the challenges to the declarations made couldn't be dealt with by GECOM, and it had to go to an election petition court. And mutatis mutandis, this challenge here is to the court. This court has supervisory jurisdiction over the officers of commissions in Guyana if they're acting in excess of their jurisdiction, as it was ruled in Holodar and also in Ulitamore. If only they have to find a case to advance the process of the elections. But it is clear, if you go into declarations, Mr. Norfield didn't make the declarations. Those are declarations of the 10 returning officers. They have not been invalidated, and the CCJ said that they cannot be invalidated except by an election petition court. And I'm taking a dim view of this matter because we are always upfront with our courts. Very much upfront, and Your Honors know that. And so I would urge, that's why, I mean, you put in a caveat, I'm not attacking you, but I'm saying, Mr. Mendes, I would have expected that you would have informed this Court of Appeal of ours that you had in fact sought to challenge Mr. Mingo's declaration. That is a declaration that has been submitted to GECOM, not the force that was quashed by the Honorable Chief Justice. That one was challenged and it was sent to an election petition court, and therefore it is valid and subsisting. And what happens here is that there's a presumption of regularity. The framers of our Constitution knew what they were doing. They knew that there's a process. Mr. Mingo is not acting alone. But when Mr. Mingo acts is when the entire electoral process and machinery dumps the product on his desk. He doesn't do anything, they bring it to him. And his duty is to ascertain and send the report for the elections of members of the National Assembly under Section 96. And you know Section 96 has been constitutionalized by Article 162(1)(b). And also the advice has to go for the election of the president. That is our law. And so
Which of your grounds are we looking at now, Mr.
So
Williams?
when we come here, Your Honor, in this case, in relation to the advice, the CEO has given a report to the chairman of tender, a report to GECOM. That report, as I said, has two facets. The one that deals with the election of members of the National Assembly, that report goes to the commission and they use it as the basis for making a declaration. That is to ascertain the results of the election and allocation of seats. And the other aspect goes to the election of the president under Article 177(2)(b). And when he tenders us advice on the Article 177(2)(b), the chairman has to act, is obliged to act only on that advice, only in accordance with that advice. I cited the law earlier. And we're saying that the court could supervise the failure of the chairman of GECOM to carry out a constitutional duty. That has nothing to do with numbers or anything. That is something that the Constitution says. You must act only on this advice and declare the person deemed in it to be elected president as elected. And that's what we have before your honors. You have a supervisory jurisdiction to do that. All the cases say that. Polydar, Hamilton, I've been in all of them. And so we urging you to act. This is not a case where you challenging declarations and all that. And that's why we said those declarations are extant and they cannot be overtaken with respect to the Lord Chief Justice. They cannot be overtaken. What that means? They cannot be rescinded or invalidated except by the election court, as the president of the CCJ said. So, Your Honor, this is the situation that we have. The declarations are not being challenged here. We're saying what we are challenging is the failure of the chairman of the Elections Commission, having received the advice tendered on July the 11th by the Chief Elections Officer, Mr. Lowenfield, which results showed that the candidate for the APNU AFC had more votes cast for that list of candidates than any other. And as a result, is deemed to be elected president under Article 177(2)(b), which further says, as a result, the chairman must declare acting only in accordance with that advice. And as in fact, in paragraph 37 of the CCC judgment, President Saunders said the same thing. Once the person identified as being deemed elected president from the elections, the chairman must so declare. Those are the actual words in the first sentence of paragraph 37. And Your Honors, we asking this court to act. It's not a situation where you're challenging declarations that involve the 10 electoral districts and all those things. It's a simple exercise that which your supervisory jurisdiction can deal with. And it's holding up elections because that is the first thing that is in place. What is being argued by Mr. Mendez is subsequent to the laying over of the July 11th report by Mr. Lowenfield. So the recount, etc., those issues also have to go to an election petition court. And, you know, let me close there because I want my learned friend has to speak, Your Honor, but I'm saying in closing that our Court of Appeal has the ability to act on that question of supervising the excess of jurisdiction by the chairman of GECOM for failing to make the declaration that is required. Thank you very much. Mr. Maxwell, please.
Good afternoon, Your Honors. Madam President, how much time do I have?
Just a moment, Mr. Edwards. We expected that your 15 minutes would be shared between yourself and Mr. Williams. That has been how we have been conducting this hearing.
Yes, please, Your Honor. We know, but we are the last submissions, and I don't think
We
we should.
sat all day from 10, it's now 3 o'clock.
We won't be
And I
long.
believe that we have traversed, the council have traversed all the issues in this appeal.
There
So,
just
Mr.
two more,
Yes.
Your Honor. Just two more issues in our respondent's appeal. We're asking the court to bear with us. The court has been very, very cooperative and with us.
Your Honor, with respect, this is John Jeremy. You did promise me at the end of Mr. Mendez's address that I would have a minute. And that's all that I need. I don't even need a minute.
All right, so Mr. Williams, we'll give you 1 minute more. Mr. Edwards, 1 minute to wrap up what you wish to say.
That's Mr. Jeremy.
No, yes, Mr. Jeremy will come to you shortly for your minute. Mr.
Okay.
Edwards, please wrap up.
What can I say in 1 minute?
No, 1 minute, just finish off with you.
Your Honors, I've heard Mr. Jeremy, Senior Counsel, comments as regards the submissions of the counsels on the other side. Use the strong words, intellectual dishonesty. I would be more charitable than that, Your Honors. And I would suggest—
Mr. Edwards, we have to just get down to the issues in this appeal. We'd like to wrap up.
That is what precisely I'm doing, Your Honors, in my own style. And I would like to suggest, Your Honors, that there can be no greater legalistic nonsense than the arguments that have been proffered by counsels on the other side as regards the weight they have attached to the nebulous, and there's no better word of describing it, recount order 60. And if I had time, Your Honors, I would have showed how counsel for the chairman's reliance on 162 1B is misplaced. Because 162 1B says, Your Honor, shall issue such instructions to ensure impartiality, fairness, and these are the important words, compliance with the Constitution and the Act of Parliament. Order 60 falls under neither the Constitution, the rubric of the Constitution, or Act of Parliament. And as my learned senior said in his very first submissions, we have the authority of Nielsen and Barker, which establishes that nothing can be read into the Constitution.
We have to close off these arguments, Mr. Edwards. These matters have been raised. You have had the opportunity to present your written submissions. All of these arguments have already been dealt with. Nielsen and Barker was mentioned earlier at this hearing. We gave you 1 minute to wrap up. You needed to share the 15 minutes with the Attorney General. So we have to urge you to wrap up.
In conclusion, Your Honor, we respectfully urge that our submissions and our contentions prevail on this court, and that the judgment of the learned Chief Justice be buried and set aside. And that is my concluding remarks. Thank you.
Thank you. Mr. Jeremy?
Your Honor, I attempted to intervene when my learned friend, Mr. Mendez, was making some very broad statements about fraud and the like. And in the same breath saying that he was not attacking anyone. But in any event, all that I wish to refer Your Honor to is the case that the Attorney General discussed in passing, that is Bara Jagdio and Riaz Holida applicants versus the returning officer, Clement Mingo. I'm not sure if your lordships have the case, but Mr. Mendez's concession and is 3 pages from the end of the transcript which I have, and it is next to 6. And Your Honor might also find it.
Your Honor, with great respect to my friend, Mr. Jeremy, those are matters which, if it was deemed sufficiently important, should have been made part of the process known as settling of the record.
All right, Mr. Khan, thank you for that. We are closing off the session. Mr. Jeremy, we allowed you 1 minute. Are you going to close off?
Yes, thank you, Your Honor. And if you just turn the page from the third to last page, it's at 16 and following of the transcript of the decision of Justice Holder on
Is that
the
included in before this court?
it's a matter of record. It's a public document.
We don't think any mention has been made of that case.
Your Honor, I can give you a citation to the case, Your Honor.
Pardon me?
It was just, Your Honor, it was emailed to the court.
Well, Your Honor, I did not get a copy of it. It might have been gone to the court, and certainly
it was emailed to all the parties, Your Honor. It was emailed to all the parties.
If my learned friend is relying on that authority, then I would ask the court to give me leave to respond to it in 10 seconds.
Yes, so Mr. Jeremy, you're relying on the case of Jagdio and Holadar against returning officer. What paragraph are you referring to? What part of the case?
Your Honor,
Is that page 16?
No, it's line 16. Unfortunately, I'm not sure how things are done, but there are no page numbers. There's just an interchange, a judgment, and interchange between Mr. Mendez and Justice Hollader.
Justice Holder.
Madam Chair, Your Honor.
So I said it was 3 pages from the end at line 6, and also 2 pages from the end at line 16.
Did you identify it in your bundle? Did you identify the case in your bundle and that portion of the case?
No, I'm not sure. I have to give way to the instructing attorney.
Your Honor, a copy of that decision was emailed to the all the parties and to the Court of Appeal Registry. That was done only this afternoon, Your Honor.
Well, Your Honor, with great respect to my friend, that puts us in
we shall come to you shortly if you insist that you wish to be heard again.
Most grateful, Your Honor.
One at a time, yes. So that's it then, Mr. Jeremy. You say line 15, 3 pages from the end of that case, and you wish to highlight the submission made by Mr. Mendez. Is that it?
So this is Justice Holder speaking and characterizing a concession of Mr. Mendez, which my learned friend, the Attorney General, has brought to your attention. So first of all, 1, 2, 3, 4 pages from the end, that concession is at line 6. And 3 pages from the end, your Honor might find that what is said has bearing on Mr. Mendez's attempt to give evidence from the bar as the quote-unquote fraud which took place in the election.
Okay, Mr. Mendez, you say you want to respond?
Yes, Your Honor. I don't think it was necessary to refer to that case for any concession that I made, because I have made it clear in the submissions before this court that the question concerning the validity of Mr. Mingo's declaration is ordinarily a matter for an election petition. And it was not necessary for Mr. Williams either to refer to that Hollader case, because I have said that that is the position as I understand it. What I have said is that if this court decides that it will accede to my learned friend's invitation to examine the validity of the recount, then the court would have to examine the validity of the declaration, because you will have ruled that matters of this sort can be entertained by the court. And if you rule that way, then whatever was decided in Hollander would then have been overruled by this court. And then you would have to determine the validity of Mr. Mingo's declaration. So I have, if anything that I have been consistent.
Thank you. All right, so Mr. Khan, you still have something to say?
Yes, please, Your Honor. I am taken a bit by surprise.
You have half a minute.
I will try to do so with the court's indulgence. Your Honor, if that is the position, we have not had an opportunity to look at that particular aspect of the argument that is now being raised. And we would like an opportunity to perhaps lay over some very short submissions regarding whatever it is has been raised in this matter. This catches us completely by surprise.
This last point?
The last point and the last case, Your Honor. It's not in the bundle. It's not been referenced anywhere before.
You wish then to send by email any comments on that submission?
We would like to do so, Your Honor, because it places us at a distinct disadvantage, as you would recognize. The rest of the parties, I might add, especially in relation to my clients, we were not part of Hollander, we were not part of Ulita Moore. So when you bring a case that is not part of the bundle, it doesn't give us an opportunity to look at it before.
So when do you think you'd be able to put in, we'll give you 1 page of submissions? Would that be enough, or you wish 2 pages on that point?
2 pages, please, Your Honor. I just simply want to have an opportunity to look at the case, given that my friend just indicated that it was emailed to us.
Okay.
Having regard to the submissions made by the Learned Attorney General in reliance to it, and which was also referenced by Mr. Jeremy.
We'll allow any of the parties who wish to respond to the reference to that case. This is the case is Jagdio and Hollander against returning officer, and the reference is to the decision of Justice Holder. If anyone wishes to respond, you are allowed 2 pages, and you have to send those submissions by email by 8 a.m. By 8 a.m. That's tomorrow, Sunday. We'll allow anyone who has anything to say about that case. We don't expect that too much more will be said. We believe that we've heard comprehensive submissions today.
May it please, Your Honor.
Yes?
May it please, Your Honor. In view of the fact that the respondents will be having this opportunity to put in 2 pages of submissions, which we don't know what they will say, could we just have an hour and a half just after to put in at least a page? We don't know what they will say.
Right, Counsel. We
said absolutely nothing on the case. All I did was to refer us to the case. I took less than a minute. So if my little friends are getting an opportunity to make submissions, when Your Honor invited me to make oral submissions for 15 minutes, and I said, I'm finished, I'm done for the day. I would ask to be allowed to put something in as well.
Okay, you've raised it at this last stage, and we are allowing the respondents 2 pages of submissions in response, if they wish, and they must make those submissions available to the court and to all the parties by 8 a.m. That's tomorrow, Sunday at 8 a.m. And if there is going to be a response to those submissions by 10 a.m.
I'm obliged, Your Honor.
Most grateful, Your Honor.
Yes, well, that concludes the hearing for today, subject to those extra submissions that we have just allowed. We thank counsel for their work in this case, their assistance.
Your Honor, may I just ask when, if your honors have an idea as to when a decision might be ready?
That's what I'm getting to. We recognize that we've heard the main appeal, and there are 2 cross appeals that are also part of the case. Having regard to the submissions we've heard, the fact that more submissions will be coming in up to tomorrow, we are in a position to say we would give our decision on Thursday at 11 a.m. Thursday.
As it please, Your Honors.
That's the 30th. Thursday, the 30th of July at 11 a.m. for decision.
Much obliged. Might I respectfully ask the Leo for my speaking notes, Your Honors?
Oh dear. Circulus inextricabilis.
Tashi, you just give me permission?
From coast to coast,
Demerara and Essequibo 99.1 FM.
Burby's 99.5 FM. Kaieteur Radio.